Legal aspects of business. I am SATHYA REKA, Assistant Professor, Department of Management, JJ College of Arts and Science, Pudukkottai. Today we will discuss about breach of contract. Before that, we will just see the introduction part. Contract is an agreement between two or more persons to create a mutual obligations which is enforceable by law. The basic elements required for the agreement to be legally enforceable contract are mutual assent expressed by a valid offer, an acceptance, adequate consideration, capacity, and legality. Then comes discharge of contract, which means when an obligation created by a contract comes to an end, contract is said to be discharged or terminated. A contract may be discharged in any of the following ways: by performance, by mutual agreement, by breach of contract, by impossibility of performance, and by operation of law. And now we are going to discuss in detail about breach of contract. What is a breach, or what is a breach of contract? Contracts are made for being performed, but there are certain circumstances when one of the parties do not perform his part of the contract. Non-performance is called breach. Now, types of breaches: material breach, minor breach, anticipatory breach, and actual breach. Material breach. The first and foremost severe type of breach is material breach. Generally, a material breach of contract involves one of the key elements of the contract not being provided or undertaken as agreed. For example, you were to purchase a computer package online and only receive a monitor upon delivery. Your contract with the provider would be materially breached. Secondly, minor breach. It is important to be clear that not all breaches of a contract will be material and hence immediately end the wronged party's obligation. In this case, there would have been a remedy to the breach of contract. For example, if a computer company delivered the equipment but a couple of pages were missing from the user manual, this would not lead to an immediate cancellation of the contract. It's a minor breach. Anticipatory breach. This occurs when a party demonstrates his intention of breach of contract. For example, Jane agrees to sell her antique sewing machine to Amanda, and the two agree on the purchase price of $1,000. The sale to occur on May 1st. On April 25th, Amanda tells Jane that she cannot come up with the money on time. Following this communication, Jane can reasonably assume that Amanda is in anticipatory breach. This enables Jane to sell the sewing machine to someone else or potentially file a lawsuit against Amanda for breach of contract. Next comes actual breach. This is, of course, the most common way that a party will breach a contract. It occurs when the time arrives for the party to perform their side of an agreement and they don't perform. Ali agrees to deliver 10 kg of rice to Hassan on 30th November. Ali fails to deliver the rice to Hassan on agreed time. This is actual breach of contract by Ali. Next, entitlement of remedy. Wherever a contract is broken, the injured party becomes entitled to one or more following remedies: rescission of contract, suit for damages, suit upon quantum merit, suit for specific performance, and suit for injunction. First one is rescission of contract. When a contract is broken by one party, the other party may treat the contract as rescinded and refuse to perform his part of the contract. Take for example, A promises B to supply 100 bags of rice on a certain day, and B promises to pay the price on receipt of goods. A does not deliver the goods on the appointment day. B is discharged from the liability to pay the price. Next comes damages. Damages means the money compensation allowed to an injured party for loss or injuries suffered by him by the breach of contract. The objects or awarding damages is not punishment but compensation. Principle of damages. Where a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damages caused to him thereby, which naturally arose from the usual course of things, or from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. Next comes quantum merit. Quantum merit is a Latin term which means as much as earned and as much as deserved. A right to sue on quantum merit arises where a contract partly performed by one party has become discharged by the breach of the other party. The right of payment is based on an implied promise by the other party to pay for what has been done. It does not arise out of original contract. Suit for specific person. Where damages are not adequate remedy, the court may direct in breach to carry out his promise according to the terms of the contract. A agreed to sell his house to B. Afterwards, A refuses to sell. As at the suit of B, court shall ask A to carry out the contract. Next one is suit for injunction. Injunction is an order of court restraining a person from doing a particular act. It is a mode of securing the specific performance of a negative term of contract. For example, if you own a website and another firm is continually copying the material on your site in violation of copyright notices and contractual provisions, then a court can award money damages and issue an injunction to prevent that conduct from recurring. So these are the breach of contracts and their remedies available. Hope you got it.